LawSikho's thorough newspaper analysis for 10th of November 2023. Okay, now let us start with the today's agenda. We'll be talking about the editorial section which speaks on speedy disposal of cases against lawmakers, what Supreme Court guidelines on the matter say, which we have taken from the Indian Express. Then we'll be talking about some news update, which will include the national news, international news, days, awards, and sports. And lastly, we'll be talking about some legal news update coming from the Honorable Supreme Court. Okay? Now, let us talk about the Supreme Court guideline on the speedy disposal of cases against the lawmaker. So, the Supreme Court has issued guidelines on Thursday, that is 9th November, to monitor the speedy disposal of criminal cases against the member of parliament, that is MPs, and member of legislative assembly, that is MLAs. So Supreme Court has made the guideline on that particular matter. Now, among the guideline issued to High Court across the country, the court called for setting up of special bench. Okay, so there is a special bench setup which will monitor the criminal cases against the legislators as well as suo motu registration of such cases by the High Court. So Supreme Court has made the guideline. It has been enforced all over the High Court, and this particular thing is done with the setting up a special bench. Now what is this case all about? So the directions were given by the Chief Justice of India, D.Y. Chandrachud led bench, while acting on a plea filed by Advocate Ashwini Kumar Upadhyay. So there was an advocate who filed the plea, and the directions were given by the Honorable Chief Justice of India while acting on that particular plea. So the plea was filed not like this year, it was filed way back before in August 2016, which sought speedy disposal of cases involving lawmakers. It also sought a lifetime ban on convicted politicians, including sitting legislators, from contesting elections rather than subjecting them to 6-year ban as laid down in the Representation of People Act. So as per the law, what it states that there would be a 6-year ban to the persons who are lawmakers or sitting legislators from contesting elections. But the plea was to sort a lifetime ban. Now, Section 8 of the Representation of People Act mainly deals with disqualification of lawmakers on conviction for certain offences. Okay? Now, what does the Representation of People Act say on this? So it was introduced by Baba Sahib Ambedkar, that is Dr. B.R. Ambedkar, in the parliament, which provides for the conduct of elections to the houses of parliament and legislatures of each state, the qualification and the disqualification for membership of those houses, corrupt practices, and other offences taking part at or in connection with the elections. So the particular act was mainly, was processing around the qualification of lawmakers, and what are the corrupt practices and what are the offences which are in connection with the elections. Although there are several provisions that deal with disqualifications under Representation of People Act, specifically deals with disqualification of legislators on conviction for offences like promoting enmity between two groups, bribery, and undue influence, along with hoarding, profiteering, or adulteration of food or drugs. Okay? However, the provision that Advocate Ashwini Upadhyay sought to replace was a lifetime ban, which was to be replaced by a 6-year ban. Okay. So, if as per the Representation of People Act, there was a 6-year ban, but the plea was to enforce a lifetime ban to a person convicted of any offense and sentenced to imprisonment for not less than 2 years. Okay. Essentially, this provision imposes a 6-year ban on persons convicted of offences with a minimum 2-year sentence. Now, while the top court in its ruling today addressed the first aspect of Mr. Ashwini Upadhyay's plea seeking speedy disposal of cases against MPs and MLA, it kept open the issue of replacing a 6-year ban with a lifetime one. So this was open, but for the speedy disposal of cases, the court has still to, have made this particular guideline. Now, So the court ruling came up today was, so the bench was comprising of Justice P.S. Narasimha and Manoj Mishra, which laid down the guidelines for monitoring the early disposal of pending cases against lawmakers. Among this are the registration of suo motu cases by the Chief Justice of various High Court across the country to monitor the quick disposal of pending criminal cases against the legislators. Adding that such cases can be heard by Chief Justice-led special bench or a bench designated by her, the court said that such cases can also be listed at regular intervals if necessary. Stating that it would be difficult to lay down uniform guidelines for trial court across the country to dispose of such cases, the court left it to the High Court to devise measures to effectively monitor such cases. Further, the court said that the priority shall be given to cases in which the lawmakers are punishable with death and life imprisonment. Beside this, cases punishable with 5 years imprisonment or more will also be prioritized. The court also ruled that the High Court can call upon the principal district session judge to take the responsibility of allocating subject cases to such court as considered appropriate. Further, trial court cannot adjourn such cases unless there are rare, compelling reasons for the same. Sufficient infrastructure facility and adoption of technology should also be ensured for this designated course by the principal district and session judges. However, this is not the first time that the Apex Court has dealt with the need of speedy disposal of criminal cases against MPs and MLAs. So there are various guidelines with respect to infrastructure, technology, what type of cases will be given priority, and what type of cases will be dealt by which court. But this is not the first time that the Apex Court has laid down the guideline to process this kind of matters. And this was a plea by Mr. Advocate Ashwini Upadhyay, where he seek a lifetime ban for the persons who are convicted as lawmaker. But this is subject to an open discussion right now, and the Supreme Court has not given any verdict on the same. Okay. Now, what are the other instances? In its 2015 ruling in PIL, that is Public Interest Foundation versus Union of India, the court directed that trials of sitting legislators facing charges against them for offences relating to Section 8 should be concluded as speedily and expeditiously as possible, adding that the trial's duration cannot exceed 1 year from the date on which the charges were framed. Under extraordinary circumstances, if the trial is not concluded within a year, the court would have to submit a report to the High Court Chief Justice along with reasons of delay. So there were several cases also wherein this particular guideline was given, and one of the cases was dealt in 2015, which was Public Interest Foundation versus Union of India. Okay, I think you got a very, very general overview of this particular editorial, and I hope this serves you a sufficient knowledge that was required. Now, let us start with the national news of the day. Western Sydney University to set up campus in Bengaluru, Australian Education Minister. So, Western Sydney University, which is ranked 375th globally, has become the third Australian university to set up a campus in India, following in the footsteps of Deakin University and University of Wollongong. Okay? Now, all foreign university intending to set up campus outside of GIFT City will be governed by the University Grant Commission regulations, which were passed last month. According to sources, the UGC has not yet made its regulation public as it is preparing an online application portal for foreign university interested in entering India. So, Western Sydney University, which is ranked 375th globally, will set up campus in Bengaluru and will set up a guideline like UGC. Now, Hitesh Kumar S. Makwana appointed Surveyor General of India. So, senior bureaucrat Mr. Hitesh Kumar Makwana has been appointed as Surveyor General of India as a part of senior level bureaucratic reshuffle affected by Centre on Monday. So he's a 1995 Batch, Indian Administrative Service Officer of Tamil Nadu cadre, is currently an additional secretary in the Ministry of Home Affairs. So he is appointed as a Surveyor General of India. India successfully test fires Pralay missile off Odisha coast. So India has successfully test fired its surface-to-surface short-range ballistic missile Pralay from the Abdul Kalam Island of the Odisha coast. Now, Pralay is 350 to 500 kilometers short range surface-to-surface missile with a payload capacity of 500 to 1000 kg. Pralay has been developed for deployment along the line of control and the line of actual control. So, it's a successfully launches Pralay missile of Odisha coast, which is Abdul Kalam Island. Now, important days की तरफ चलते हैं. Legal Services Day 2023, which is celebrated annually on November 9th, which was officially enacted on the same day in 1995 with the adoption of Legal Services Authorities Act 1987. Since then, Legal Services Day has been consistently celebrated across the various states of India with the primary objective of promoting legal awareness among its citizens. The establishment of National Legal Services Day serves to raise awareness about the availability of free legal aid for all citizens, regardless of their background or identity. So, it is celebrated on November 9th, marking the adoption of the Legal Services Authorities Act 1987. Clear hai? Chale. Uttarakhand Foundation Day is celebrated its 23rd foundation today with great enthusiasm and fervor. It was on this day in 2000 the Uttarakhand was formed, carving out from Uttar Pradesh. On this occasion, various programs are being organized in different parts of the state. Now, the president honored 4 people in Uttarakhand Gaurav Samman for their outstanding contribution in various fields. Okay, so Uttarakhand Foundation Day celebrated on November 9th, marking its 23rd Foundation Day. Clear है? Now, international news की तरफ चलते हैं. Antony Blinken in Japan for G7 foreign ministers meet. So, US Secretary of State Antony Blinken has shifted his intense diplomacy on the Israel-Hamas war to Asia with an appeal for the group of 7 leading industrial democracies to forge consensus on how to deal with crisis. Now, the group of G7 nations are Britain, Canada, France, Germany, Italy, Japan, and United States. This is an important moment as well as for the G7 to come together in the face of this crisis and to speak as we do with one clear voice. So, Antony Blinken in Japan for G7 foreign ministers meet. इसमें आप ये याद रखिएगा कि G7 nations कौन-कौन से थे. Clear है? लीगल अपडेट की तरफ चलते हैं जो बॉम्बे हाई कोर्ट से आ रही है एंड इट टॉक्स अबाउट अ रीओपनिंग इज नॉट परमिसिबल एज इट फॉल्स विद इन द परव्यू ऑफ अ चेंज ऑफ ओपिनियन. सो द बॉम्बे हाई कोर्ट has held that reopening is not permissible as it clearly falls within the purview of a change of opinion which is impermissible in law. So the Bombay High Court bench, Justice K.R. Sriram and Justice Neela Gokhale has observed that the basis on which the AO issued notice alleging that there was information that suggests escapement of income was an internal audit objection. Information is explained in section 148 to mean any objection raised by Comptroller and Auditor General of India and no one else. So this particular case comes up as a, it comes up in terms of the internal audit objection and the information that result into escapement of the income. And the particular case name is Hasmukh Estates Private Limited versus ACIT. Now, the next news coming from the Supreme Court, which upholds the constitutionality of IBC provisions relating to personal guarantors, says adjudicatory role can't be read in section 97. So, in a significant judgment by the Supreme Court, which has upheld the constitutionality of the provisions of Insolvency and Bankruptcy Code, relating to personal guarantors insolvency resolution, which were introduced through amendment made in 2019. The statute does not suffer from any manifest arbitrariness to violate Article 14 of the Constitution, which is declared by the bench led by Chief Justice of India. And the case was Surendra B. Jivra Jika and another versus Omkara Asset Reconstruction Private Limited. And the provisions were Section 95 to 100 of Insolvency and Bankruptcy Code. ठीक है? So it has upheld the constitutionality of Insolvency and Bankruptcy Code provision relating to personal guarantors. Say adjudicatory role can't be read into Section 97. ठीक है? That's all for the today's news update. And if you want to revise your previous TNA, do check out the quiz link which is there with the description of this particular TNA, which will help you in clearing the exams. That's all for the today's TNA. Happy Dhanteras to all. Take care.